her accusers, same as the mover of that motion. They have taken a stand. They have agreed with the contents of the motion. So how do they then run at the end of the race and sit as a tribunal and we expect them to be impartial on the issue? Now, my lady, her goose is cooked. If she appears before that quasi-judicial tribunal, it is not impartial. It has a predetermined outcome. And that's why there is all this mad rush to take her through the process for the sake of formality, not for any other reason. So we then submit, my lady, that the mere fact that this motion has been supported by 68, that is 99.9% of the House, means there is no impartiality. On that basis, again, my lady, we submit that there is a prima facie case that justifies the issuance of the last limb of my submission, my lady, is that indeed the petitioner has demonstrated sufficient justification for issuance of conservative orders I will limit my submissions on that issue because I know my learned friend at time involvement will address you on the issue of jurisdiction. Perhaps I will have an opportunity to respond. But then, my lady, the petitioner has approached this court and invoked 3 jurisdictional mandates. One of those mandates, my lady, is the mandate that allows this court to interpret whether anything done or said to be done under the Constitution is in contravention of the Constitution. In our pleadings, the petitioner has identified 3 issues that require this court to scrutinize, to interrogate, and render an opinion in terms of interpretation of the Constitution under the mandates provided for under Act 165(6) of the Constitution. Some of those questions, my lady, is whether the County Assembly can commence impeachment proceedings within 3 months of assumption of office, even before the government is fully constituted. Two is whether Article 181 of the Constitution ought to be read together with Section 33 of the County Government Act to import the meaning and the mystic provided for under Section 33 and 27 of the County Government Act, where the County Government Act sets the minimum period within which a member of the County Assembly can be recalled to a minimum period of 24 months. So the petitioner will be referring this court to give directions in exercise of its mandate under 165(6) on whether indeed you can commence impeachment proceedings before the expiry of the 24 months. Another issue is whether, again, reading Section 27, 4 and 5, as read in Section 33 and Article 181, whether a governor can be impeached, or rather proceedings for impeachment of a governor can be commenced more than once during the term of that governor. And those are weighty and serious issues, constitutional issues, that cannot be addressed as of now and a justified determination arrived at. It will require the court first hear all the parties on the issue, deliberate on the same, and render. By that time, my lady, the process, the impeachment process will have taken place. On that ground, then, my lady, it is only fair for the court to issue conservatory orders and allow the court to have time to interrogate the issues, render judgment on merit before the impeachment process can take place. As I sit down, my lady, I submit that the impeachment proceedings do not have to take place immediately. They can be suspended. There will be no prejudice whatsoever on the part of the respondents if that motion for impeachment is suspended, just to allow the court to interrogate the issues at hand. On the other hand, there will be total prejudice, irreversible in fact, if the impeachment process proceeds. Because the process is time bound. Once impeachment takes place, forwarded to the Senate, then the deputy governor takes over. How do we remedy that situation? And my lady, I believe you're quite aware of this issue that fell before your hands with the Wajir matter, where we had 2 office holders just because conservative orders either were not issued or were not compliant. It almost threw the county of Wajir into a constitutional crisis. We do not want that moment again. We do submit that there is evidence to show that indeed the conservatory orders are not issued. The County Assembly of Meru will proceed on 30th of November at 10 a.m. to hear and render its judgment on the impeachment process. That has been communicated in very strong terms, not only through the letter dated 22nd November, but even in the notice paper of 30th November contained at pages 287 of our bundle, indicating that indeed the County Assembly is set to debate this motion the day after tomorrow. We respectfully ask the court to grant the orders, reserve the stratum of the suit, and allow the court look at the issues of merit and then judgment. That is all my lady, unless you have any questions.
Yes, my lady, on behalf of the respondents, the motion is strenuously opposed. I emphasize strenuously, my lady. To that end, we have filed 4 sets of documents. Number 1, the preliminary objection dated 25th of November 2022, a replying affidavit sworn by Charles Muredi Launi on the 25th day of November 2022. We have filed written submissions dated the 26th day of November 2022. And we have also filed a list and bundle of authorities dated 26th of November 2022. And we will in summary be making 4 points. Point number 1 is that this court has no jurisdiction at this stage of the dispute to issue the conservatory order sought or any other relief of that character. The operative issue in our objection, my lady, is at this point in time, and I'll clarify that later. Point number 2 will be attempting to show you that in any event, she has not made out a case for the issuance of conservatory orders or an order of that character. My lady, in the event you disagree with us, because the court is perfectly entitled to disagree with us on those 2 points, we'll be making the point that even if it were to be assumed for argument's sake that they have a good case before you, our submission is they don't. The solution does not lie in the issuance of a conservatory order or any order of like character, and that this court, if it finds any defects in the process, it can issue directions on what safeguards ought to be observed in the process without necessarily stopping it. In the event the court disagrees with us on the first 3 points, my lady, we'll be hoping to persuade you, notwithstanding the merits or demerits of their case, based on our lived history and the nature of society we have, the court would be establishing a very dangerous precedent which would have the effect of emasculating the mechanisms in our Constitution for public accountability and political accountability set out in Article 181 of our Constitution as read in Section 33, and the standing order in question, which is Standing Order number 65. I begin with the first point, my lady. Likely the matter before you is not new. What is before you is exactly what happens and what has happened since we got this 2010 Constitution. Whenever a governor has been threatened with impeachment, they rush to court. So luckily, there is no shortage of judicial opinion on whether the relief being sought from you can issue at this stage. Our submission in simple is that there is binding precedent from the Supreme Court of the Republic of Kenya in the case of Justice Kariuki Mate and another versus Martin Nyaga Wambora and others. That is Supreme Court petition number 32 of the year 2014. Before I take you through the highlights of this decision, my lady, I wish to point one thing. The petitioner's entire case for a conservatory order is based on the decision of the Court of Appeal involving the same parties as the case I am now highlighting before you. But when you read the authority at page 57, that is the decision of the Supreme Court, you will note the decision they relied upon was set aside by the Supreme Court. The legal consequence is that that decision is not authority for any legal proposition to the extent that it was entirely set aside by the Supreme Court in the case I just cited for you. When you open the decision from the Supreme Court, which is at page 57, my lady, you note that the crux of it is whether extent to which courts can interfere with parliamentary processes which are in actual progress. What happened in this matter, my lady, is that the High Court issued the order you're being asked to issue. The Assembly nonetheless ignored it and impeached the governor for him. The High Court vacated the impeachment on the ground that it was in violation of a conservatory order. The matter went to the Court of Appeal, where my friend would have to leave the proceedings. And the Court of Appeal agreed with the High Court. However, my lady, when the matter went to the Supreme Court, a number of things are noteworthy. One, the Supreme Court ruled that orders of the type being sought from you should not issue, that the processes should be allowed to run to their logical conclusion, and if there is a dispute, then it can be ventilated. But the judiciary cannot hamstring, that is the language the Supreme Court used. It cannot hamstring. The Supreme Court went on, my lady, to say something I've never seen, which is why this is important. That because the judiciary had hamstrung the Assembly, contrary to the doctrine of separation of powers, instead of waiting for the process to end, the Supreme Court actually ruled that on the facts of the case, that was a good ground not to give effect or not to obey the conservatory order that had been issued. Number three, my lady, which also I don't usually see in my few years of practice, now 15 and counting. When you read that decision, you'll find the Supreme Court did not just talk at reversing or setting aside the decision of the Court of Appeal, which is the one that was before it. The judgment says the conservatory order is annulled. What usually happens with appellate courts, my lady, is they reverse or set aside. It must count for something that the Supreme Court not only strongly reprimanded the High Court for issuing conservatory orders at this stage of the dispute, but actually annulled. That's another polite way of saying the order was null and void as initially issued. And that is the context in which the Supreme Court says such an order could not be given effect to. So to the extent, my lady, that the Supreme Court has ruled the court has no jurisdiction at this stage of the process, there would have to be something very exceptional, very dramatic, that will give this court the courage, given the provisions of our Article 163(7), to nonetheless issue. And time permitting, I'll actually show you a case where the High Court has the courage to issue them in very unique circumstances which do not now hold before you. That position, my lady, of the Supreme Court is reflected in yet another decision from this court by the late Justice Louis Onguto. The decision by Justice Onguto is the case of Mwangaza Ria and two others versus Speaker Muranga County Assembly and two others. When you read that decision, my lady, it's at page 156 of our battle. It says a number of things which answer all the complaints by the petitioner. That one, the judiciary is not the appropriate forum to interrogate whether the assembly has good ground for impeachment or not. Number two, it says the actual impeachment forum is at the Senate. The motions that we are dealing with at this stage, though part of the process, the county assembly is not the impeachment forum for governance. The county only does the groundwork and preliminary work. The proper forum is the Senate. We haven't reached there. And that can be confirmed from paragraph 92, my lady, of the decision at page 169. And just to confirm, that's exactly what the Supreme Court also said. Number three, that decision says, a position also affirmed by the Supreme Court, that the question of prejudice, which is one of the considerations before giving a conservatory order, does not arise at this stage of the dispute, because the Senate is duty bound to confirm compliance with requirements of due process, requirements of fairness, requirements of issuance of proper notice. My lady, I told you I'll tell you a case in which those orders were issued. I think I can mention it now. It is a case of Anne Mombi Waiguru. The decision is not in our battle, my lady, but we had agreed with my colleague. I can refer to it earlier on in the morning. When you read this decision, my lady, of Anne Mombi Waiguru versus Mwangaza County Assembly, it is petition number 123. It confirms everything I've told you so far of the year 2020, just 2 years ago, my lady. This is one case where conservatory orders were issued, notwithstanding the position of the Supreme Court, and the explanation is given that the impeachment motion was commenced in that county during the COVID-19 lockdown, when it was impossible to call the governor a hearing because there were restrictions on face-to-face interactions, there were restrictions on movement, it was impossible to hold public participation, and that is the sole ground. But when you read that decision, my lady, it confirms everything. It shows you that conservatory orders can only issue under exceptional circumstances. We have read the case before you. We have not been told what are exceptional circumstances. But it's our case that the application and the petition before you fail a very basic threshold laid down in a case called Anarita Njeru versus Republic. You know, my colleague is happy to tell you, we have invoked this article, we have invoked the other article, and we have invoked the other article. Of course they have invoked them. The case of Anarita Njeru tells us it is not enough for you to invoke constitutional provisions. You must do more and tell us, in reasonable degree of precision and clarity, what is the manner in which your right has been violated? What is the extent to which it has been violated? It is not enough to sing Article 50, Article 47, or whatever. I mean, anyone can do that. That's the easy thing to do. That decision of Anarita Njeru, my lady, is set out in page 13 of our bundle of authorities, which is also bound together with our submissions. And the particular excerpt, my lady, is on the third paragraph at page 18 of our bundle. My lady, in fairness, it's important to point out that initially, Mutuma and I weren't born when this decision was issued. The remarks there, which have now become law, were initially issued as obiter. I don't know where Ndeg Wanjiru was born. He's whispering something to me. 1979, my lady. My lady, that rule that a petition alleging infringement of fundamental rights and freedoms must demonstrate with reasonable degree of clarity the specific provision that is breached and the manner in which it has been breached has been confirmed by the Court of Appeal to be the law, now not just obiter, as initially issued, in the case of Mumo Matemu versus Trusted Society of Human Rights and 5 others. That decision is at page 22 of our bundle. So it's no longer just obiter. And again, on this case of Mumo Matemu, my lady, again the courts issued various orders, reversed certain appointments. The Court of Appeal eventually ruled actually the petition was a non-starter right from the outset. It never met the basic threshold of Anarita Njeru versus Republic. Let me now take you through why we say that they have not made their case anyway, even if we are wrong on all these technical things. They tell you the motion has been signed by a stranger. We have annexed at page 19 of our replying affidavit a document that shows the person who received the motion is the deputy clerk. Page 19 of our replying affidavit. He is the deputy clerk. Number 2, my lady, we have in our list of authorities showed you that section 21 of the County Assembly Services Act, which is at page 172 of our bundle, empowers the deputy clerk of the assembly to exercise all the functions of the clerk during moments of vacancy or inability on the part of the clerk. So nothing turns, if that is the prima facie case, then it is also prima facie that they have not understood the actual position. They tell you the matter is sub judice because one of the grounds is that there is a case before the ELRC and it's one of the grounds of proposed impeachment. There are a number of things they haven't done, my lady. One of them is they haven't told you that that ground is only one of 15 grounds. So even if you are to believe that that is correct, you still remain with 14 main grounds of impeachment. But they also haven't told you, although the main grounds are 15 in number, the specific grounds of impeachment are 68 in number. I don't know whether it's coincidence, my lady, that there are 68 grounds and there are also 68 members who signed it, but we'll deal with the issue of the members. But there are actually 68 specific acts and omissions that inform the proposed impeachment. They also didn't tell you that understanding Order 90, which they were happy to read to you, the parts that suit their case, but they didn't read for you the part of studying Order 90 that doesn't support their case. And when you read the whole of studying Order 90, which they have annexed, my lady, you will note it is not the mere pendency of a case in court that makes the matter sub judice within the meaning of studying Order 90. One, you have to show in the case of a civil dispute that it has been fixed for trial. They have not mentioned that. The matter is still in the interlocutory stages. You have to show, they mentioned this, but they didn't show you how, that the impeachment motion would prejudice the fair determination of that matter. You have been told the assembly is biased because 68. But the law only requires a minimum number of MCAs, that is 1/3. It does not forbid supermajorities from signing onto that motion. But if we are wrong, my lady, given the sentiment from the Supreme Court, and given the Supreme Court tells us the Assembly and the Senate are the appropriate forums, the fact that it has been signed by 68 is equally a ground for restraint on the part of the court. That's the other side of the coin, even if we take it that they are right. But my lady, again on that issue, the Senate is the constitutional safeguard against any bias, against any malice, against any mischief on the part of the Assembly. And I invite you, my lady, to take judicial notice that there are very many instances when county assemblies have impeached a governor and the Senate has refused to uphold the impeachment. So when the Supreme Court and Justice Onguto tell you that the Senate is the actual locus of the relevant event and it is the actual safeguard, it's not for nothing. They are telling you fair trial, Article 50. They have not told you how it will be breached. But also what they haven't told you, from their own authority, the one they are relying on, although it was reversed by the Supreme Court, we are told impeachment is a tool of policy and political accountability. It is not about civil liability. It's not about criminal culpability. Therefore, the invocation of Article 50 is misconceived. And this view, my lady, that the matter before you is not an Article 50, it's not about civil or criminal culpability, can be confirmed from their own decision, which we have actually annexed in our Bible at page 123. It is the holding number 4 from the Court of Appeal. They have told you, my lady, that the reason this good lady is having this problem is because she's a woman. They have not attached a single document to show you these utterances. They say they were made by the move of the motion. They were made by certain male politicians. Not one of them is attached or even referenced so that we know it exists. Maybe they were just not able to lay their hands on it. They have told you legitimate expectation that she would serve for 5 years. The constitutional provision that provides for a term of 5 years is not more important than the constitutional provision that says if you engage in certain types of conduct, you could be impeached, and that term would be cut short. So again, the claim for legitimate expectation is maybe another. They have told you the reason MCAs are this bitter, and the reason 68 out of 69 have signed this motion, the real issue is the Ward Development Fund. Why that cannot be a prima facie basis, my lady, is one, the impeachment motion does not even mention, even in one of the 68 grounds, anything to do with the Ward Development Fund. The document speaks for itself. The other thing they haven't told you is that even if we were to assume, because my lady always do my litigation on the assumption that the adversary is right, even if we were to assume, for argument's sake, that that's one of parts of the driving factors, they didn't tell you MCAs who have no stake on the Ward Development Fund, specifically nominated MCAs, have equally signed that motion. Yet they have nothing to gain or lose as far as the Ward Development Fund is concerned. They have told you the clerk has short-circuited the process. He's jumping the gun. They have told you, yes, there are a number of things they have told you on that allegation, and prima facie they are misconceived for the following reasons. One, they tell you the motion has been put in the order paper. My lady, we challenge them to show you. Because what they have annexed is not an order paper. It is a notice paper. And the standing order they rely upon clearly shows there are two types of documents: an order paper and a notice paper. I don't know where they got that, but clearly we'll be happy to be shown. Maybe it is my glasses playing tricks on me. We'll be happy to be shown where is the order paper that forms the. Because the document, my lady, at page 282 of their budget, is a document says orders of the day, and its date is 23rd November. It's not the order paper of 30th November. The document at page 285, which they are relying on, it speaks for itself. That it is a notice paper. It is in bold, in big font, my lady. It's a notice paper, not an order paper. They tell you the motion has not been moved. So the clerk is just jumping the gun. But what they don't tell you is that this notice paper, not order paper, my lady, and just for the benefit of the court, the notice paper is the document that shows matters that are tentatively planned for business before the assembly. So So those matters may or may not find themselves in the order paper when the relevant date arrives. That's the difference. The order paper specifies the events of the day in question. The notice paper is more like a timetable for an entire week. And this can be confirmed from starting order number 39, which they have attached. It can be confirmed from starting order number 45, among many others. So what they are relying on here, my lady, because you note in that notice paper at page 286, which they want you to believe is the order paper. Of course, that's why the notice has been given, and it's clear there under item 30th November 2022, and the impeachment motion is indicated there. First of all, this document defeats their case in two ways. One, it is not an order paper. Number two, it contradicts their own claim, which they began with, that the motion has not even been moved. The document is there, it shows the motion has been moved. At page 287 of their own bundle, the motion has been received by the speaker, it has been, if you check all the stamps and annotations on their own bundle, all the steps have been taken.
What page is that?
287 of their bundle, my lady. You note it is approved by the speaker, it has been received by the clerk, and of course in the other page I have showed you the notice paper. You are told, my lady, the clerk was wrong to issue the newspaper advert and that was rushing the process and jumping the gun. What they didn't tell you, which is confirmed by the Supreme Court and the decision of Justice Onguto in the Mwangaza Ria case, and even the decision I showed where the order was issued because of COVID restrictions, what they didn't tell you is that all those cases confirm that the process and sequence of events is preordained by statute and the standing orders. The moment the speaker approves that motion, notice must be given for 7 days, and they must be debated and voted upon by the 10th day. The reason, my lady, as you find in the replying affidavit, it became therefore necessary, guided by that Supreme Court decision and the other decisions, was that that is the only way the public participation could have been held. Because if you wait for the 7 days and you must dispose of the business within 3 days, it will mean there will be no room for public participation. And our answer, therefore, is this complaint about the newspaper is misconceived. It is based on a misreading of the timetable cast on 30, and the Supreme Court has said a lot about those timelines. So they simply cannot be faulted, the clerk cannot be faulted. You have been told the reason you should issue the order is because the assembly is not infallible. We agree it is not, but none of us is, not even my lady. And therefore, that really, without more, cannot be a ground for hamstringing the process contrary to the decision of the Supreme Court. They tell you there is no nexus between the governor and the allegations in the motion. The motion does not leave the nexus. Two answers. First of all, the motion speaks for itself. We'll leave it to my lady to see whether it establishes that nexus. But more importantly, the Supreme Court as well, Justice Onguto as well, the other case of Iguru as well, that the forum for establishing that nexus is not in a court of law. It is not even before the county assembly. It is at the Senate. So it is them who are actually jumping the process, even as they accuse the clerk. And this decision can be confirmed, the case of Kawira Ria, at paragraph 92, my lady. That's where Justice Onguto held that issue of nexus, the courts are not the appropriate forum. They tell you there is a glaring loophole and that there is a serious constitutional question that must be determined because Section 27(4) of the County Government Act, as read with Section 5, puts a moratorium of 24 months before you can recall an NCA. And they tell you because there is no similar provision putting a moratorium of 24 months before you can impeach a governor, therefore the court should make law and create such a moratorium. That is the main question they tell you. It's a weighty question of constitutional law. My lady, what they're asking you to do is to issue an advisory opinion. That jurisdiction lies with the Supreme Court, not with this court. And in any event, if you check our preliminary objection, we address the question of justiciability. And number 3, my lady, they're asking you to make law that because Parliament has refused to make that law, you make it. Clearly, that's not within the province of the mandate of this court. It cannot be a prima facie reason. The court is ill-equipped to examine the policy rationale why no such law exists. They tell you freedom of religion. They have not showed you how the assembly has stopped her. She's a bishop. So she hasn't told you whether the assembly has stopped her from preaching or presiding over Sunday, whatever. We'll be happy to see how that, but it's not evidence, not even an allusion to it. They tell you freedom of expression. They have not told you how an impeachment motion stops the governor from expressing herself. No evidence produced. Not even weak evidence, madam. They tell you Article 37, correction of illusion of untrue and misleading information. They have not told you which are these untrue and misleading statements that have been made against the governor that would supposedly require correction and deletion. They have told you Article 47, and luckily, Article 47 is answered by their own documents. They have produced 2 letters from the clerk. Those letters are produced in their own application, my lady, as BKW9, I believe, at page 48 and at page 50 and 51. When you read those letters, my lady, you see the 7 days notice has been given, the one they are complaining about. The public participation has been promised. As a matter of fact, it was taking place today. She has been given a right to respond in writing if she so wishes to the motion. When you go to page 50 of their own annexure, the second paragraph tells her that the motion was laid on the table. The very same motion they were telling you has not been laid and has not been moved. By their own annexure, it says it was laid on the table, pursuant to Standing Order number 65-2. But more importantly, my lady, she is again invited to appear before the Assembly in a sitting of that year for purposes of making oral representations. If you check the other letter, she was given the opportunity for written representations. She has now been offered an opportunity, in addition, oral representation, and she is in addition been allowed to appear either in person or through an advocate. And she has been told even when she appears, she will also have the opportunity to respond at page 51 to the issues raised in the debate. Now, not the issues in the motion, the issues raised in the debate. She has also been promised, which is this Article 47. We would want to hear, after all those undertakings, which is this Article 47, and Article 49, and Article 50 and 51. She has told you a complaint about legally obtained evidence. But she has not told you, not in her submissions, not in her pleadings, which is this evidence that was obtained illegally. And that's why my lady will say, this case does not meet the threshold in an narrated Karemi Jero versus Republic. She is telling you EACC is investigating some of the allegations. Again, she forgets there are 68 specific allegations. She has not told you how that could possibly be a bar to impeachment. And she has told you, lastly, she will suffer prejudice. The answer of which we got from Justice Louis Onguto, that it is premature at this stage we are talking about to talk about prejudice or irreparable harm or the matter being rendered nugatory, because my lady, when you read Justice Onguto's decision, because you are given a oral scenario that she may be impeached, the governor takes over, Justice Onguto has said it in black and white, that even if all these processes were to be allowed to go to their full conclusion, and the governor were impeached and removed from office, and the deputy so on and whatnot, the court would still have a jurisdiction after the event to interrogate the process, and if they found that she was not fairly impeached, to reverse it and return her to the position. So the question of prejudice doesn't arise. So my lady, I have so far addressed you on my points. I want to summarize by telling you as follows, and I don't know how much time I have left. 18 minutes. So my lady, I'll just say two things, then I'll allow my colleague to use the remainder of our time, Mr. Boniface. My lady, I sincerely hope I have shown you that this bill before you is just one of those where people allege article this, article that, without really laying on a prima facie basis, because at this stage we are not interrogating the merits, a basis for invoking that article, contrary to Anarita Karimi. I've shown you the policy and position of the Supreme Court. But if I am wrong, my lady, and I have been wrong very many times in my career, so I won't be surprised. If I am wrong in all these things I've told you, and they are right in everything they have told you, it does not necessarily mean that you must issue a conservatory order. The court may agree with them that they have laid that prima facie case, the court has jurisdiction at this stage and whatnot, but your jurisdiction under Article 23 is to issue appropriate relief. And what is appropriate relief is not just a relief that pleases the applicant. It must be a relief that balances all due considerations. And we suggest that relief, my lady, if you find any fault with the process, you can give us guidance on how the business that is pending should be, the remaining stages should be concluded. That will still be a relief. It will be within the ambit of appropriate relief. My last point, so that Kawira will have some time a little bit, is what I told you, the scheme of incentives. My understanding of why the Supreme Court lambasted the High Court in the manner it did is that issuance of reliefs such as those sought before you without good ground would create the incentive to every governor who is faced with impeachment rush to courts, save in the knowledge that the courts will too readily issue these orders and therefore frustrate processes that are time-bound under the Constitution, processes that are time-bound under the Section 33 of the Government Act, and in fact, emasculate Article 181 of our Constitution. My lady, there was a point, part of the reason we had issues in the constitutional reform process about vetting of judges and whatnot, courts at one time made it impossible, by way of example, this is a matter the court can take judicial notice. At one time, our court made it impossible to prosecute anyone for corruption because they would quickly rush to court and say, my fundamental right to this, my fundamental right to this, and the prosecution would be killed. We know where that took our country. And the court therefore must ask itself, if it gives this order, even in good faith, what scheme of incentives does it create for political players? Because for them, the message will be, all you need if you're facing this type of accountability mechanism is dash to court, get an order, frustrate everything, and you're safe, which is another way of saying the courts will have killed at post 181. I'll give the floor now to my colleague Boniface.
My lady.
20 minutes, Ria.
15 minutes.
What's the other name?
Boniface Kawira Ria. I believe I'll be able to complete within 15 minutes left. My lady, first of all, or foremost, I will pick up from where my learned senior left. And I think in difference to our star what I would term to be a star authority, the decision in Justice Kariuki Mate versus Martin Yako Ambora, from paragraph 84, which is on page 89 of our band of authorities. The question of separation of powers, the petitioner applicant has made everywhere of what they term to be violation of the doctrine of separation of powers. From paragraph 84, my lady, you will note that the Supreme Court, in this decision, that overturned the authority that the petitioner applicant solely relies on in the application, noted that the court, or the judiciary rather, when faced with a circumstance where there is an ongoing parliamentary or legislative process, the process is not complete, the process is still running its course. This inchoate process, my lady, ought not to be stopped. And the actual words that the Supreme Court used is that the court should be guided by the inner restraint within the architecture of the Constitution. Inner restraint in not encumbering any other government agency to stall its constitutional motions and to stall what is its prescribed constitutional mandate. From the same decision, my lady, the Supreme Court was emphatic that the parliamentary processes should be allowed to run their full length. Unwarranted intrusion, unjustifiable intrusion in these parliamentary processes is an undue fetter on the independence of each arm of government, and the county assembly being an arm of the county government. And therefore, the court should shy away from undue interference with these running processes until they are completed. Therefore, my lady, we humbly submit that the jurisdiction of this honorable court has not been properly invoked. The supervisory jurisdiction of this honorable court, or even its review jurisdiction, maybe, is not properly invoked, and these processes should be allowed to run their full length. And by our preliminary objection to the petition and the application, the jurisdiction of this honorable court is ousted, and the county assembly should be allowed to conclude its prescribed constitutional mandate
as laid under Article 181 of the Constitution, and the other statutory provisions. I believe Section 33 of the County Governments Act and Order 65 of it. Impeachment is the remit of the County Assembly, and the court should only intervene. The court should only intervene when rights have been violated. And we submit to this case, my lady, that no rights have been violated. The petitioner applicant has been invited to appear in person, to make oral submissions, and to appear with our legal representatives before the Assembly. My lady, Kenya is a constitutional democracy. We are a representative democracy. Article 10 of the Constitution is explicit on the place of public participation in governance. And the public too, my lady, has not been left out. By the newspaper advertisement of 22nd of November, which was done timelessly in order to allow the public sufficient time to make their representations to the Assembly. Whether in writing, there's a provision for them to send their memoranda via mail, or to deliver it physically to the Assembly. And as a matter of fact, my lady, public participation was ongoing today, just here at the County Assembly.
When making noise all over, we will not concentrate.
So, my lady, impeachment is a sequential and hierarchical process. The first step is tabling of the motion before the Assembly, which has been duly done. Then debate of the motion. And after a resolution is made, the same is transmitted to the Speaker of the Senate, which acts as the impeachment court. We submit respectfully, so my lady, that this honorable court cannot delve into the merits of the impeachment motion. The Senate will, at the opportune time, when the motion, that is if the Assembly resolves so, and it could as well, my lady, the governor could appear and exonerate herself. If it gets to that point, at the opportune time, the Senate will look into the evidence, the Senate will look into the falsity, the veracity, and the truthfulness of the allegations. And the petitioner would appear before the Senate, together with the witnesses, and the mover of the motion, together with his witnesses, if any, will have every opportunity to make submissions and before the Senate, and they will be cross-examined on the same. So therefore, my lady, that process should be allowed to conclude, after which the jurisdiction of this honorable court could be properly invoked. On the last issue, my lady, the petitioner alleges that there is a breach of the legitimate expectation of the people of Meru, that she would serve them for 5 years. But the petitioner has not told us whether this legitimate expectation has legal backing. Impeachment is an accountability mechanism that is constitutionally ordained. It is in the Constitution. And should the governor or the applicant, rather, commit such breaches of the law, then the Assembly, in exercise of the delegated authority of the people, can remove her from office. Legitimately so. So therefore, my lady, legitimate expectation cannot be invoked. That principle doctrine cannot be invoked to frustrate or impede constitutional processes. The petitioner applicant seems to erroneously believe that she has a right not to be impeached, while impeachment in and of itself is a constitutional process. So in summation, my lady, I still believe I have 2 minutes left.
You have 3 minutes.
I will conclude in 3 minutes. In summation, my lady, we urge you not to grant a conservatory order assault. The orders will offend the overarching doctrine of our Constitution, that is separation of powers. They will amount to an undue fetter on the constitutional mandate of the Assembly, and they would gravely affect the operations of the Assembly. No cogent evidence has been presented before you, my lady, to prove or show any threat to the petitioner's rights. And therefore, my lady, we submit that the application is not merited and the same should be dismissed with costs to the respondent. Thank you, my lady.
I believe that having sat here listening to the respondents, counsels on it, I believe they have either totally misunderstood our case or misunderstood the law and wants the court to misapply the law. Our case does not seek for this court to bar the County Assembly of Mary from discharging its constitutional mandate under Article 181. We are not in any way saying that the petitioner has a right not to be impeached. That is not our case. Our case is simple, that the impeachment process as envisaged under Article 181, under Section 33, under Standing Order 65, must be undertaken in a manner that is in compliance with the law, from day one to the last date. Day one is when a member conceives the motion and processes the motion through the clerk and the speaker all the way to the floor of the House, culminating, of course, with the Senate if it must get that point. What my learned friends are telling this court is that the court can allow rights to be violated at the initial stages because a remedy is to be found at the tail end. The Constitution does not envisage where that room is given for violation of rights. Indeed, my lady, conservatory orders are sought either in anticipation or ipso facto. So when there is a threatened breach of the Constitution, a party cannot wait for that moment. You have also been told, and I will take that as an admission from my learned friend, that the court can fashion an order to safeguard the rights of the petitioner. That is an admission that indeed the process as presented to us is faulty. Otherwise, there would be no need to safeguard a process that is in compliance with the law. And what would be this remedy that is meant to safeguard? The court does not just issue orders from the blues. My lady, Article 23 of the Constitution lists the orders available in such a situation. Declaration of rights, and I'm reading Article 23(3), an injunction, a conservatory order, a declaration of invalidity of a law, an order of compensation, and judicial review. Those are the remedies, the only remedies available under the Constitution, under Article 23. So, for the respondent to invite the court to fashion a safeguard remedy would be to ask this court to place itself in the position of the county assembly and redraft the standing orders. We ask the court to decline that invitation. My lady, I find a lot of solace in the judicial president in the Martin Wambora case, Supra. And allow me just rely on one section of that judgment. I'm looking at paragraph 2.
Which one? The Supreme Court one?
No, the Martin Wambora case, the Court of Appeal, the 2014 EKNI. At paragraph 2, the court says, first of all, the court adopts the holding of the Supreme Court of South Africa.
Same paragraph?
2 of that judgment. And this is what the court says, guided by the Supreme Court of South Africa, that no parliament, no official, and no institution is immune from judicial scrutiny. What the respondents are telling you is that they are immune. The county assembly is immune. The court should not scrutinize their affairs. It should allow them violate, and then the petitioner will have a chance later to remedy the situation. The Court of Appeal, again, my lady, is guided by the Supreme Court of Uganda in the case of Paul K. Samogede, the same paragraph, and says, the Constitution, not Parliament, nor the executive, nor the judiciary is supreme. My lady, Article 50 was not given by the County Assembly of Mary. It is not given by the judiciary. When you look at Article 19, it confirms that fact, that human rights are inherent. They are not given by the state. So the County Assembly of Mary, and Article 25, my lady, which is that the right to fair hearing is one of those rights that you cannot limit. So my lady, what does the Constitution say? It gives this court the powers to grant conservative orders under Article 23. You do not need the guidance of the Court of Appeal. You do not need the guidance of the Supreme Court. You only need to look at the Constitution. Has it granted that mandate? There has been a lot of misapplication of the Supreme Court holding in this court, in this case, my lady. But I've also had a lot of blowing of hot and cold air from the respondents. One is that the Supreme Court did not say that the High Court cannot issue conservatory orders. Each case, my lady, is unique in its own circumstances and facts. The court said that there were no sufficient grounds in that case to issue conservatory orders. But in no way did the Supreme Court hold that the High Court cannot grant conservatory orders. My lady, look at the Supreme Court holding in the matter of interim Independent Electoral Commission as the applicant in Constitutional Application number 2 of 2011, I believe it was an advisory, which has been quoted by the Court of Appeal in the Martin Wambora case. And this is what the Court of Appeal says and borrows from the Supreme Court. It is at paragraph 33 of that judgment and appearing on page 126 of our bundle of authority. And this, it says, the Court of Appeal says, the Supreme Court stated in that case that I've quoted, the IBC case, the Supreme Court stated that where the Constitution exhaustively provides for the jurisdiction of a court of law, the court must operate within the constitutional limits. In our view, the High Court has 4 distinct constitutional jurisdictional mandates relevant to the question of removal of a government from office. These are, and they proceed to issue. 1 is jurisdiction under Article 165(6) that seeks to supervise quasi-judicial bodies and tribunals, which is exactly what the petitioner is asking you to do. Exercise your jurisdiction under 165(6), supervisory jurisdiction. This is the Supreme Court saying that. 2, another jurisdictional mandate is vested under Article 165(3)(d)(2) to hear any question whether anything said to be done under the authority of the Constitution or any law is inconsistent or in contravention with the Constitution. The petitioner again is asking you to find whether what is said to be done by the County Assembly under Article 181, under Section 33, under Standing Order 65 is in contravention of the Constitution. You do not need anyone's permission to invoke that jurisdiction. You have been granted that jurisdiction. Do not sit that jurisdiction. Again, and I can go on and on, you will have a chance to look at 126 for the sake of time. So that then, my lady, you are properly seized of this matter. You have the capacity to issue conservatory orders. The Supreme Court has not gagged you from doing that. So the question then, my lady, should be, have we demonstrated sufficient grounds? And the threshold of issuing conservatory orders, as I began by saying, the court should not look at the substantive issues. Regrettably, my learned friends have taken quite some time urging you on the merits of the main petition. They have done that. I urge the court not to look at that, because I restrain myself from addressing the merits of the case and reserve them for the main court. It is unfair for them to do that. So what the court should concern itself is, do we have sufficient grounds? Do we have a threat to violation of rights? You have been told that the process of this motion, is not a stranger. Looking at the motion for impeachment, it is signed by someone calling himself the acting clerk of the County Assembly. Their formation is actually confirmed by someone calling himself the acting, not the deputy. And there is a clear distinction in law of the two. A deputy is just a deputy who deputizes. Once the deputy takes over in an acting capacity, it must be through a legal instrument. You have not been given that legal instrument that appoints the deputy as an acting, in an acting capacity, though it is signed by someone indicating someone in an acting capacity. But there has been admission that indeed one of the grounds for impeachment is find the governor in contempt of court. But the respondents are telling you that is so negligible. It is only one of the grounds. So there is an admission that indeed the matter is active in court. When you look at paragraph 8 of our affidavit, it confirms when the matter was in court and when it will be in court next. That has not been rebutted. If indeed that has been brought to the attention of the County Assembly, as the move of this motion, withdrawn that ground. Has it been done? So there's a matter that will still be discussed unless that has been withdrawn. There was ample opportunity for the move of this motion to indicate indeed, having found that this matter is sub judice, I will not proceed with the prosecution of the case. So only on that one ground alone, this application is merited. My lady, again, my learned friends have not addressed you on who issued the notice. Is it in compliance with Article 65? The notice ought to be issued by the mover in compliance with Order 65. Where is the clerk coming in? What interest does the clerk have to issue that notice? It again confirms the bias of the work process. The motion is forged, my lady, and ought to be set aside at least until the court is given ample time to process the merits of the same. My lady, what would be then the essence of this whole petition if conservatory orders are not issued? My lady, just wait for just 3 minutes. I will stick with you. I only have one or two other issues. So, my lady, then, the purpose of conservatory order is to preserve the substratum of the case. I do not need to overemphasize. If the court does not issue conservatory orders at this juncture, what will be remaining for determination at the tail end? What would be the import of those declarations? What would be the import of that interpretation on when a governor, on when proceedings for impeachment can be initiated? This whole matter will be rendered nugatory unless conservatory orders are issued. But even in the case relied upon by my learned friend, the annual court case, you will realize Justice Corilla at the end of the day granted conservatory orders. That is a confirmation that you must look at the specific issues before you and form an opinion whether conservatory orders are justified. That order cannot be. Just to conclude, allow me just refer you to your own judgment that you delivered months ago. The ink is not even dry on your judgment. The Wajir case. What did you say? And you are not wrong, my lord. What my learned friends are asking you to do is to sit in appeal of your own finding in the Wajir matter. That judgment has not been appealed against, and if it has been appealed against, it has not been overturned. This is what you held together with your two brothers, my lady. At paragraph 19, my lady, this is what you say. All state organs were bound by the Constitution and the law, and the courts retained the power to interpret, protect, and promote the Constitution. A careful and thorough consideration of the impeachment process of the first petitioner demonstrated that the County Assembly was not operating properly.
You know, my colleague, I used to doing cases on the same side, so I was restraining myself from unnecessarily vexing. A reply is limited points of law, and you cannot open new territory because I want. Only that he's a very good friend, we're usually battling on the same side. I don't know why he left me this time, but let him stick to the rules.
And I must digest. I do not need to live on that point. The issue is my lady, and this is an authority that we prepared in advance and shared with my learned friend. And I'm only responding to the issue raised by my learned friend, where he said that the court cannot issue conservatory order at this juncture. So it is not a new issue per se, my lady. It is an issue that I'm responding to. So in this judgment, my lady, you say that if there is no compliance with the procedure and the law, nothing prevents the court from issuing conservatory orders. In very clear terms, my lady. The most instructive part of your said judgment, my lady, is to be found at paragraph 23. Which says a party could not be required to suffer illegality, breach of rights, and risk distorted injustice on the source that his grievance would be remedied upon appeal or other review of the government has been done. That is exactly what they are telling you to allow a breach, to allow breach, to allow violation, then later you will have the right to, you will have the opportunity to look at that violation. My lady, the Constitution gives you power to issue conservatory orders. It is not in dispute that valid and weighty legal issues have been presented to you for determination. You cannot possibly determine those issues now. Grant conservatory orders, then will be left to address the issue. Maybe on that basis, we ask you to dismiss the PO and grant us the conservatory orders, as there will be no prejudice on the part of the respondent. They have not even demonstrated any prejudice. If this process is halted just for a few days, to enable us to canvass the issues. In those cases, my lady, allow the applications for conservatory orders and dismiss the PO on most of them. Most of them.
Unless it will be allowed to attend virtually?
Yes.
I'm only asking because I'm based in
No
Nairobi.
problem at all.
Okay.
Yes.
Madam.
So we are going to be virtual.
Yes, my lady. Yes.
We have a petition number P025 of 2022. The first petitioner, Francis Minion, Mwanda Kaberia, Peter Lee, Jesse Mutuma, Peter Kizenji, Josephine Ettore, Francis Mregi, Lori Magiri, Not Kitonga versus County Assembly of Meru, two others.
Your leadership, yes, please. I know it has been a long afternoon. I do not intend to keep you more. My name is Stephen King. I do appear for the petitioners in that petition. Fortunately, we also have the presence of my other friend, Senior Terry.
It is not on record.
Yes, it is not on record. I'm very sure you have the benefit of the direction granted.
I'm wondering whether the issues raised here can already be answered in the ruling that we will
The leadership that is why probably it would have been appropriate for me to address it then, so that we can just deal with the question of consolidation, then we can address that one.
I do not agree with the matter of consolidation which we have served.
But my petition is quite different from what is being advanced therein.
So you want,
Slightly different.
so you wish to serve?
Service will be done. I do not think it shall achieve much more by urging the application. We would rather wait for
Not
the
expected.
we'd rather wait for the ruling in this application. I think it will save much question. So the leadership, even as you direct to serve, you greatly grant us prayer number one, on the basis that much has taken place, both the public and the participation has been initiated and Mca received. The leadership, if you look at my certificate, is very specific. I've even indicated the number of, or the period that the purported public participation has taken place today, from 8 a.m. to 1 a.m. A maximum of 3 hours to cover a county that hosts over 1 million residents.
The application is
Yes, expertly. That will
I
convince
think
you.
the directions in this matter will be given on 30th November at 8:30.
Most of that, we shall also,
But sir,
we shall serve.
yes, so the first order is that it's up. The direction will be given on 30th.
Most of that.